Trump has been gagged multiple times by the court. Yes, as soon as multiple gag orders had been issued, it seemed like Trump has violated them, and that's gonna be a whole thing. And I know we did a whole video on how Trump was claiming he was under a gag order when he wasn't. Well, now the gag orders are really coming down. U.S. District Judge Tanya Chutkan has heard enough, and after a 2-hour hearing about Donald Trump's habit of calling prosecutors and witnesses liars, thugs, and traitors, the judge has issued an order barring him from making any public statements targeting witnesses, lawyers, and court staff. Now, the order applies to all parties, but so far only one of them has been suggesting that some witness kinda sorta maybe should have been executed, and that person is Donald Trump. Judge Chutkan said Trump can, quote, assert his belief that this prosecution is politically motivated, but his, quote, First Amendment freedoms do not allow him to launch a pretrial smear campaign. So of course, Trump quickly exercised his free speech rights and blasted the order.
I'll be the only politician in history that runs with a gag order where I'm not allowed to criticize people. Can you imagine this? Do you believe this? I'm not allowed to criticize people, so we'll see. We'll appeal it, and we'll see, but it's so unconstitutional.
Now, after the Justice Department indicted Trump in DC, Trump vented on Truth Social, if you go after me, I'm coming after you. Now, there are obviously many ways that you can interpret that statement. Trump did not identify anyone by name, nor was it even clear his comment was about the DC case. He could have been talking about any of the people on his enemies list, such as Barack Obama, Hillary Clinton, or the editors who dropped him from the Forbes 400 list. However, the government contends that Trump was obviously talking about the DC prosecution. Special counsel Jack Smith said Trump subsequently, quote, made good on his threat by making inflammatory comments about the case on an almost daily basis. For example, Trump described Judge Chutkan as a biased Trump-hating judge who deserves a filthy and crime-ridden district that is over 95% anti-Trump. He also posted derogatory things about Bill Barr and Mike Pence. So Smith filed a motion asking the court to stop Donald Trump from making public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Prosecutors said that, quote, Trump's relentless public posts marshaling anger and mistrust in the justice system have already influenced the public. For instance, on August 5th, 2023, police arrested Abigail Jo Schrei for making, quote, racist death threats to Judge Chutkan. The government also said that jurors are already fearful of blowback by angry Trump supporters, citing the criminal trial of Brandon Fellows, a Trump supporter who was at the Capitol on January 6th. You might recall that during the trial, the jury sent the court a note expressing concern that Fellows might have information about the identity of jurors. But naturally, Trump opposed the motion. He argued that a gag order would be a prior restraint on political speech that would violate his First Amendment rights. Quote, the Biden administration charged President Trump, the leading contender in the 2024 presidential election, for statements he made as president. Now, keenly aware that it is losing the race for 2024, the prosecution seeks to unconstitutionally silence President Trump's, but not President Biden's, political speech on pain of contempt. And Trump argued that the court has less draconian tools to ensure a fair trial, including a change of venue, postponement of the trial, extensive searching of prospective jurors, and sequestration of the jurors as well. Those are arguably less restrictive options than the blanket protective order. And Trump wasn't wrong. Americans have First Amendment rights to freedom of speech, and criminal defendants have a constitutional right to a fair trial. And you don't give up those rights even when you're accused of 90-something crimes.
I got 99 problems, but
Judge
ain't one. Hit me.
But there are scenarios where a person's right to a fair trial can be in conflict with someone else's free speech rights. If there is too much commentary about a case, it can taint the jury pool. Now, this is a fairly underdeveloped part of constitutional law because criminal defendants rarely have such a burning desire to make pre-trial statements, as well as the means to fight the court when they issue these types of orders. But the Supreme Court has held that judges can limit attorney speech when a lawyer's words have a substantial likelihood of materially prejudicing a legal proceeding. In Gentile versus State Bar of Nevada, the court said that attorneys aren't entitled to the same degree of protection as the media. But what if a person is making incendiary statements as a criminal defendant? Well, the Supreme Court has never explained which standard applies to the speech of a criminal defendant, let alone the standard that applies to a person running for president. In Trump's case, the government argued that the court should apply the standard articulated in Gentile versus State Bar of Nevada, while Trump argued that the Gentile standard only applies to lawyers. Trump contended any speech restrictions on defendants must survive strict scrutiny, meaning that the government must prove that any prohibited speech would constitute a clear and present danger to the administration of justice. At the hearing, Judge Chutkan announced that she would sidestep the issue of the proper standard. She said, quote, "I intend for any order I issue to meet to satisfy either test." Now, as you can probably tell, Trump is going to need a good lawyer to fight all these gag orders. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find you the right attorney who can. Because getting a lawyer right away is so important to make sure you get a full recovery. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. Now back to all the gag orders. But different courts have different rules. In Trump's New York hush money case, Judge Juan Manuel Merkin issued a protective order preventing Trump from publicly discussing the evidence disclosed during the discovery process. The order also prevents Trump from receiving the names or other identifying information about people who work for prosecutor Alvin Bragg, other than prosecutors and law enforcement members, until the start of jury selection. However, Judge Merkin refused to characterize this as a gag order. He said he would not impose a gag order because, quote, "such restraints are the most serious and least tolerable on First Amendment rights." That does apply doubly to Mr. Trump because he is a candidate for the presidency of the United States. In Merkin's view, the government would need to show that Trump's speech presented a clear and present danger before he would restrict it. In Trump's New York civil trial, Judge Arthur Engeron issued a limited gag order after Trump posted a photo of the judge's clerk with Chuck Schumer along with a link to her private Instagram profile. But Judge Engeron was not amused. He said, quote, "Consider the statement a gag order forbidding all parties from posting on social media about members of his staff." Judge Engeron did not limit Trump from speaking about the judge, though. In Washington, D.C., the local federal court rules are stricter. In order to avoid interfering with a fair trial or prejudicing the administration of justice, Rule 57.7 prohibits anyone from making a public statement about, quote, "the identity, testimony, or credibility of prospective witnesses, and any opinion as to the accused guilt or innocence, or as to the merits of the case or the evidence in the case." If the case is a widely publicized or sensational criminal case, the court, on motion of either party or its own motion, may issue a special order governing such matters as extrajudicial statements by parties, witnesses, and attorneys likely to interfere with the rights of the accused to a fair trial by an impartial jury, the seating and conduct in the courtroom of spectators and news media representatives, the management and sequestration of jurors and witnesses, and other matters which the court may deem appropriate for inclusion in such an order. Trump ally Roger Stone ran afoul of this rule when he posted a photograph of Judge Amy Berman Jackson with crosshairs superimposed over her image. The judge said Stone was trying to, quote, "gin up more public comment and controversy about the legitimacy of the Mueller investigation, the House investigation, and to get people to question the legitimacy of the prosecution." She concluded that Stone was acting in a manner that would pose a substantial likelihood of material prejudice. Now, the gag order hearing in front of Judge Chutkan went about as well as you might expect. The judge went through several of Trump's statements, asking both sides to comment about whether Trump's comments interfered with a fair trial or prejudiced the administration of justice or the credibility of witnesses. Judge Chutkan was most concerned about whether Trump's statements about the judicial system and its employees violated local rules. She said she was aware of and did not care about what Trump said about her, but she was appalled by Trump's comments about Judge Engeron's clerk. She wanted to know if John Lauro, Trump's attorney, agreed that such statements were out of bounds. Lauro said he would advise Trump that such comments were a bad idea, but he also argued that, quote, "nothing has happened like that in this case, and nothing like that will happen." Judge Chutkan was skeptical. Lauro said there's no need for an order because when a judge or lawyer tells Trump to do something, he does it. Quote, "because if your honor makes that kind of admonition, it will be followed, and it has been followed." Lauro really did say that, but without cameras in the courtroom, I don't know if he said that with his straight face. Judge Chutkan asked Lauro about the things that Trump said about Bill Barr and Mike Pence, and Trump posted a video attacking Barr for not helping him overturn the election and criticized Pence for not throwing out electoral votes.
Why does Fox News constantly put on slow-thinking and lethargic Bill Barr, who didn't have the courage or stamina to fight the radical left lunatics?
And she also wanted Lauro to address Trump's September 22nd comment about Joint Chiefs of Staff General Mark Milley. Trump said, quote, "this guy turned out to be a woke train wreck who, if the fake news reporting is correct, was actually dealing with China to give them a heads up on thinking of the President of the United States. This is an act so egregious that in times gone by, the punishment would have been death." Lauro said that Trump's commentary about Milley, Pence, and Barr is acceptable because, quote, "none of them have ever suggested that the criticism of President Trump has led to any diminution of their ability to do their jobs or testify or do whatever they want to do in terms of criticizing President Trump. Just the opposite, they give as good as they take. Judge Chutkan disagreed. Quote, "That's right up to, would no one rid me of this meddlesome priest? If you suggest that someone is deserving of execution, that's not a far stretch to imagine a situation where one of the millions of followers of this person decides to go ahead and do that." Laura responded by saying she hit the nail on the head and brought up the time that a deranged Bernie Sanders supporter shot Steve Scalise, which really is not exactly the point that he was trying to make there. Laura said that the gag order proposed by the government would mean that Trump couldn't truly campaign against Joe Biden, but even under the government's proposed order, the prosecutor conceded that Trump wouldn't be barred from attacking Joe Biden or Joe Biden's Justice Department. But the government didn't totally have its way during this hearing. The prosecution sought a very broad gag order that would have undermined Trump's ability to challenge the prosecutions as politically motivated. The DOJ wanted to bar Trump from making any derogatory statements about the Department of Justice or Merrick Garland. Judge Chutkan was reluctant to impose a restriction on Trump's ability to challenge his prosecution by the DOJ. Quote, "It seems awfully close to his right to assert his innocence and criticize the government." And the Supreme Court emphasized in Gentile that speech critical of the exercise of the state's power lies at the very center of the First Amendment. And while the government tried to persuade Judge Chutkan that Trump's attacks on the city would somehow prejudice the jury pool, she disagreed. Quote, "This is not about whether I like the language Mr. Trump uses. This is about language that presents a danger to the administration of justice." So after a 2-hour hearing on the motion, Judge Chutkan issued an order granting the motion in part and denying the motion in part. Quote, "In order to safeguard the integrity of the proceedings, it is necessary to impose certain restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed." The judge found that Trump went beyond merely criticizing the judicial process. He crossed the line by stating that, quote, "Particular individuals involved in it are liars or thugs or deserve death." The court finds that such statements pose a significant and immediate risk that 1, witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats. 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial as well as trial stages of this case. The judge rejected Trump's contention that the court can't limit his speech because he's running for president. Quote, "The bottom line is that equal justice under the law requires the equal treatment of criminal defendants. Defendants' presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings." And her order applies to all parties to the case, not just Donald Trump, though in fairness, it's only going to affect one person. It limits that person or people from making public statements that target prosecutors, defense counsel, the court staff, and any reasonably foreseeable witnesses or the substance of their testimony. But the judge did allow criticism of herself. And accordingly, Judge Chutkan ordered, quote, "All interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target 1, the special counsel prosecuting this case or his staff, 2, defense counsel or their staff, 3, any of the court staff or other supporting personnel, or 4, any reasonably foreseeable witness or the substance of their testimony." Now, that is a gag order, but it's not a total gag order. Trump is not prohibited from maintaining his innocence, describing his prosecution as politically motivated, or criticizing the government. Now, if a judge finds the defendant has disobeyed an order of the court, the person can be found in criminal contempt. And criminal contempt can carry a penalty of days in jail, thousands of dollars in fines, or both. The court can also impose stricter orders and fines. A person in violation of a court's order can have their bail revoked, meaning that would put the person in custody until trial. That's what happened to Sam Bankman-Fried, who was under house arrest while awaiting trial. Prosecutors said that Bankman-Fried tried to intimidate former FTX CEO Caroline Ellison by publicly sharing her diaries. And he allegedly also tried to contact FTX General Counsel Ryan Miller over email and the encrypted messaging platform Signal, which violated the judge's conditions of release. So the judge in that case revoked his bail. But if you're anticipating that Trump would be put behind bars for violating any of these gag orders, you probably should lower your expectations. Given the circumstances of these cases, I wouldn't expect that to happen unless it was the most extreme of circumstances. And judges know that keeping Trump from making disparaging remarks is playing a game of whack-a-mole, but courts do have other options to coax him into compliance. For example, Judge Chutkan previously suggested that if Trump cannot follow the court's orders, she will bump up the March trial date. And it's likely that Trump doesn't want any of his trials to happen before the 2024 election. And at the hearing, John Lauro told Judge Chutkan that she could avoid the First Amendment issues by postponing the trial until after the general election. She brushed off that suggestion because it's probably the strongest tool she has to get Trump to comply. But of course, as soon as these gag orders were issued, it seems that they were violated. We're now getting a look at just how hard it is to coordinate a presidential campaign during a trial. On October 20th, the New York Attorney General alerted Judge Engoron that Trump had failed to remove a post about the judge's law clerk from his campaign website. Judge Engoron said, quote, "I learned that the subject offending post was never removed from donaldjtrump.com and in fact has been on the website for the past 17 days. Incendiary untruths can and have led to serious physical harm. I will now allow the defendant to explain why this should not end up with serious sanctions or I could possibly imprison him." He asked Trump lawyer Chris Kise why Trump shouldn't face serious sanctions, and Kise said it was just an accident. Trump had deleted the post from his social media accounts, but it was still on the campaign website. And after a brief recess, Trump's lawyers told the judge that nobody really saw the post. Trump's lawyers said that the campaign sent emails to roughly 25,000 recipients, but only around 6,700 of those messages were opened. But Judge Engoron was not amused. He fined Trump $5,000, but warned Trump not to do it again. Trump was, quote, way beyond the warning stage. But since Trump was a first-time offender, he felt that it was only appropriate to fine Trump a nominal amount. And Trump quickly gave Judge Engoron another opportunity to ramp up his fines. On the day Michael Cohen was testifying in the civil case, Trump offered these comments.
If we had a jury, it would have been fair, at least, even if it was a somewhat negative jury, because no negative jury would vote against it. But this judge will, because this judge is a very partisan judge, with a person who's very partisan sitting alongside of him.
When the judge found out about these remarks, he assumed they were directed at the judge's clerk, a clear violation of the order. Judge Engoron said, quote, "It's very easy for the public to know who that person is. I'm very protective of my staff, as I believe I should be. I don't want anybody to be killed." And then the judge asked Trump's lawyers why there should not be severe sanctions for this blatant, dangerous disobeyal of a clear court order. Chris Kise said Trump was obviously talking about Michael Cohen, not the court clerk. Kise said that the context was that Cohen was partisan. This seemed dubious because Trump wasn't discussing the substance of Cohen's testimony and Cohen was not sitting next to him. It seemed clear Trump was referring to how the court was administering the case, that this is a bench trial instead of a jury trial, and that the judge and his clerk were Trump haters, and the clerk is the one that was sitting close to the judge. The judge tabled discussion of the matter until after the lunch break when Trump agreed to take the witness stand where he was put under oath. Judge Engoron asked Trump who he was referring to, and Trump said, "You and Cohen." The judge said, quote, "First of all, my principal law clerk is very close to me. You and I can see each other, and we are close, but not as close. And there's a barrier between us, so wouldn't that at least be somewhat ambiguous as to whom you are referring?" Trump didn't back off of his claim that he was referring to Cohen, which was probably smart on his part. But the judge said, quote, "As the trier of fact, I find that the witness is not credible," and he fined Trump $10,000. Now, again, this fine is small in Trump's world, but the overall finding is a big deal. The judge, who's going to render a verdict in this case, found that Trump lied to his face. Other judges will probably take note, as will the special counsel. And speaking of Judge Chutkan's case, Trump appealed the gag order to the DC Circuit of Appeals, where he asked for an emergency stay pending appeal. Trump's lawyers also asked Judge Chutkan to stay her gag order while they prepared a full appeal, and Judge Chutkan issued an administrative stay of her own order. Now, the gist of Trump's appeal is that the order is unconstitutional because it limits his right to engage in core political speech. Trump argues that the part of the order restricting comments about Barr, Milley, and Pence is unconstitutional. Quote, "The witnesses that third parties listening to President Trump have supposedly intimidated, former Vice President Pence, former Attorney General Barr, and former Chairman of the Joint Chiefs of Staff, Mark Milley, are extremely high-level public figures who have voluntarily entered the public arena and invited the cut and thrust of public debate by openly criticizing President Trump. Thus, the prosecution's speculation that these witnesses will be, quote, intimidated by President Trump's criticism is non-credible on its face." And Trump claims that the government should have produced affidavits from these witnesses attesting that they've faced intimidation and harassment. And these are not crazy arguments. Trump got support from the ACLU, which probably hasn't happened all that many times before, which filed a brief supporting Trump. Anthony Romero, director of the ACLU, said, quote, "If we allow his free speech rights to be abridged, we know that other unpopular voices, even ones we agree with, will also be silenced. As much as we disagreed with Donald Trump's policies, everyone is entitled to the same First Amendment protections against gag orders that are too broad and too vague." The ACLU argues that the word targeting in the judge's order is also too vague. Quote, "In the context of the order, it could mean something as innocuous as name or identify or something much more violent. One could target another with respectful but vigorous political advocacy or target them for physical violence or death." The ACLU agreed that there is a serious risk that Trump's words can inspire other people to violence, but it contends that the mere fact that others have threatened actions against trial participants after hearing defendants' words is not enough. Of course, surprising no one, after Judge Chutkan stayed the order, Trump wasted no time in resuming his commentary on witnesses and prosecutors. Here he is describing Jack Smith as deranged in a way that would have violated the original order. In the same post, he attacked Anthony Pratt, an Australian businessman who says Trump shared classified information with him at Mar-a-Lago. And Trump also commented on Sidney Powell's guilty plea, clarifying that while she was never his attorney, she did a, quote, valiant job of representing a very unfairly treated and governmentally abused General Mike Flynn. Which is interesting because Powell took a plea deal and is now expected to offer testimony against Trump in the Fulton County case and could be a witness in the case that Judge Chutkan is presiding over in Washington, D.C. So Judge Chutkan has a conundrum on her hands. Trump's team will brief the court on freedom of speech issues and prosecutors will respond. But it's anyone's guess what will happen next. Judge Chutkan could invalidate the original gag order and issue a more narrowly tailored gag order, which could create a whole nother set of appeals, or maybe not, because it might be so narrowly tailored that it's not worth fighting over. Or she could let the original appeal play out. But Trump is wasting no time in issuing a ton of statements that probably violate the original now stayed gag order. Trump's comments include calling Jack Smith deranged. He comments on the substance of Mark Meadows' alleged testimony and has been lashing out at cooperating witnesses as weaklings and cowards. But Trump's gag order has been covered extensively by more than 190 different news outlets, and 29% of the reporting is coming from the left and 21% is coming from the right. And if you compare the headlines, you'll start to see some interesting frames emerge. On the left, you have outlets using terminology like imposed, ordered, and prohibits with reference to the gag order, while on the right, you'll find outlets using words like slapped with or hits. Those word changes are subtle, but they play a big role in how readers perceive the story. The first set of words might imply authority and precedent, while the second set of words might imply something unfair or immature. And all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. At Ground News, every story comes with a quick visual breakdown of the political bias, factuality, and ownership of these sources' reporting, all backed by ratings by 3 independent news monitoring organizations. I especially like the Ground News comparison feature, which highlights specific differences between left and right reporting. For the story on Trump's gag order, you can see the left-leaning outlets tend to focus on Trump's legal team opposing the gag order, while the right focuses on statements by Trump calling the indictments election interference and a witch hunt. Now, Ground News also has a blind spot feed, which highlights stories that are disproportionately covered by one side of the political spectrum. This kind of analysis is so important so we don't live in an echo chamber or get misled by subtle and sometimes not so subtle language in the news. So give Ground News a try by clicking on the link that's on screen right now. Ground News is giving LegalEagle viewers 30% off their Vantage plan. This includes access to a feature called My News Bias, which is basically a dashboard for your news diet. You can find out your top news sources, whether you're engaging with diverse perspectives, and what your favorite topics are. So you can try it out by going to ground.news/LegalEagle or click on the link that's on screen right now or down in the description. You can get started for less than $6 a month and support an independent news platform working to make the media landscape more transparent. And after that, click on this link over here for more LegalEagle, or I'll see you in court.